You had just concluded by saying that the defendant thought Conrad was about 16 years old.
Yeah. Yes, I did.
Did you then discuss with him the next victim?
Yes, I did.
And would you share with that discussion with the jury?
He said he met Matt Turner at the bus station in Chicago, offered him money. Turner agreed to return to Milwaukee. Mr. Dahmer had been to the bathhouses in Chicago 2 nights that weekend, had one lover for 1 night only, was turned down on the second night. He and Turner returned to Milwaukee. They watched videos and then gave Turner the drink mixture, strangled him, and a few days later dismembered him and saved the skull. Put the flesh in the trash bags and did not use the acid routine. Put the bones in a freezer with some flesh left on them. Put them in the freezer so that they would not smell. Kept the skull and the unclean bones in the freezer.
Did it indicate that he returned to Chicago the next weekend?
Yes, it does. Yes, he did.
What happened then?
He went to a certain nightclub, gave the name of the nightclub, and he met Jeremiah Weinberger. Said that Weinberger performed oral sex on him in the corner at this tavern, and said that Weinberger wanted to be Mr. Dahmer's, quote, houseboy for the weekend, unquote. On the way back to Milwaukee, Weinberger curled up next to Mr. Dahmer on the bus, and Mr. Dahmer said this, quote, embarrassed him. Should be embarrassed me, I'm not an exhibitionist or anything, unquote. Referring to Turner being demonstrative embarrassed Mr. Dahmer.
Did you say Turner?
Turner's being demonstrative on the bus to Mr. Dahmer embarrassed Mr. Dahmer.
I thought we were talking about Weinberger.
Weinberger.
I'm sorry. Mr. Weinberger is being demonstrative on the bus.
Thank you.
When asked about getting caught or getting into trouble, he implied that there was, quote, so many close calls and nothing happened. I felt successful, unquote. So again, an interpretation here, this impressed me as another contributing factor in that if your attitude is that I have a successful routine going, I have not been discovered or caught, I've had close calls and I've always succeeded in not getting caught, this can certainly affect your attitude about continuing, and you are less deterred from continuing if in fact you are getting away with it. So I think this attitude helps explain in part the continuation of his behavior. There's also a good statement in the confession regarding the issue of his not being caught. Returned to his apartment. They had sex, watched videos. Weinberger told him that he had to be back next Monday morning. They drank.
All right, would you read that line after you skipped a line there? After he said, I felt successful.
Oh, I'm sorry. So many close calls and nothing happened. I felt successful, unquote. Said he never thought about who they might have been or about their families. I remember asking him at this juncture, did you ever wonder if, this guy was a student or was he this or that, or, he might have been somebody's son and this kind of stuff. And that was his response. He said he never thought about who they might have been or about their families. Quote, I blocked those thoughts out of my mind, unquote. And again, depersonalizing the individual or impersonalizing the individual contributed to allowing him to do what he was doing. Returned to his apartment, had sex, watched videos. Weinberger told me he had to be back Monday morning. They drank in the morning. And he tried the drill technique with boiling water. quote, to make them zombie-like, unquote. Weinberger woke up 2 hours later and he was, quote, disorientated, unquote. He gave him some more pills and a second injection of boiling water, and Weinberger fell asleep, left Weinberger on the bed, and then said the second injection made him comatose, meaning unconscious. So Dahmer left for work and then returned and said he was, quote, happy, unquote, to see that Weinberger was still alive, but disappointed that he was in a coma. Again, reflecting Mr. Dahmer's attempt to develop a new routine procedure of having a live but compatible sexual partner. He said he wanted them to be mentally alert enough so that, quote, could follow my commands, unquote. Said he spent all day Tuesday trying to revive Weinberger, took pictures and had sex with him, did not know what to do, was hoping, waiting for the effect of the injection to wear off, and that Mr. Weinberger would become more alert. Weinberger was comatose when he again left for work. And then when he returned the next morning from work, found that Weinberger had died. Took pictures and masturbated and put him in the bathtub. Put the head in a bag in the freezer, left the body in the tub with a bleach water mix. Said this was the first time he used the bleach water mix, and then he closed the shower curtain. A few days later, met the next victim, Oliver Lacey, black, quote, well-built and attractive, unquote, on the streets around 3 in the afternoon on a Sunday afternoon. And Mr. Dahmer was scheduled to work that Sunday evening. Said Mr. Lacey was, quote, especially attractive, unquote. Mr. Lacey was not gay. Then I asked him, he's approaching these people on the street. And this is somewhat of an outgoing, assertive thing, and he agreed that he was not, quote, shy, unquote, that he would go up to strangers and make sexual propositions on the street. They returned to the apartment, gave Lacey the mixture, quote, immediately, unquote, because he knew that Lacey was not gay and would not want to stay around, did not use a drill technique, had bought some chloroform in an attempt to experiment with trying to prolong the effects of being drugged after the sleeping mixture, to prolong the period of unconsciousness. And he told where he got the chloroform. And they drank alcohol in the apartment that afternoon. But the problem that confronted Mr. Dahmer then was maybe somewhat new, but he was not free. And he was scheduled to go to work at 11 p.m., so he called in sick, and this was what led to his dismissal from his job. Chloroformed Lacey with a dust mask, and dripped the chloroform onto the cloth. Lacey woke up Monday morning about 4 a.m., and he said this technique did not work either. Then gave him some sleeping pill mixture and coffee and strangled him with a strap. And he said that Straughter was the first one that he used a strap on.
So with respect to Lacey, he first drugged him, then attempted to extend the period that he would be under the influence or under his control by attempting to chloroform him. Is that correct?
That's true.
This was not successful. Lacey woke up and he gave him some coffee with more pills in it. Is that correct?
That's true.
Then proceeded to strangle Lacey with a strap after some period of time.
That's true. Had sex and anal sex and kept a portion of the biceps. Said Lacey was, quote, one of the more attractive ones, unquote. He said he still had frozen body parts from the earlier case, but was not going to use them. He said, quote, on the spur of the moment, unquote, took some fresh muscle, never froze the biceps, but did freeze the heart for later consumption, took many pictures. Weinberger was still in the tub. Did both Lacey and Weinberger together. put the flesh in trash bags, and froze the bones for later, quote, acidification, unquote.
When you say he did them together, I mean he defleshed them together?
Apparently. Kept both heads for later cleaning, agreed that, quote, that the, quote, freezer was full of heads, unquote, and figured out that Lacey, Weinberger, and the Chicago bus station case heads were in the freezer. Said 3 were painted and several were unpainted. Said he drank much more and on a daily basis after losing his job. Formerly, he just drank on weekends. He said, quote, I didn't want to keep on doing it. That's why I tried the drill technique. So again, an attempt to start a new approach. Said several individuals were not gay, at least 5, and he gave their names. The next and last individual was Joseph Bredehoff, Caucasian. After he lost his job, this is Mr. Dahmer. This case is after Mr. Dahmer lost his job.
That he was drinking excessively and met him in a near West Side area and then returned to the apartment in the afternoon?
That's right.
Did you then proceed from there?
Had sex, gave him the sleeping mixture and strangled him, did not take any pictures, was on the bed for 2 days, and decomposed rapidly and had maggots on his face. Placed the body in the bathtub, put the head in the freezer. Flesh and trash bags and the bones in the freezer for later cleaning. Said he bought a new, thicker and stronger 57-gallon trash barrel because the previous barrels were too thin. They allowed too much odor through the plastic. Did not like the smell. Would open the windows to let the smell out. When asked, said, quote, very much so, unquote, he was behind in cleaning up the bones. Said he had the bones of the, quote, Chicago bus station case, unquote, Lacey and Bredehoff in the freezer. And said his plans were to keep Lacey's skeleton, but then acidify the other 3 skeletons. Had the bones in the new barrel without any acid in it, had not bought any acid. When he was arrested, had Lacey's bones in the freezer and Lacey's head in the refrigerator, and he had used the head the night before for masturbation purposes. A few days later, was at the was at a mall, approached an individual, talking about Tracy Edwards, I believe. Talked to him the week before. The individual came up to Mr. Dahmer and asked for a cigarette the week before on Wisconsin Avenue. Mr. Dahmer saw him a week later in the mall, approached him, offered him money, and they returned to the apartment. Edwards drank the 151 proof rum, and Dahmer drank the beer. They did not have sexual contact. Sir Dahmer wanted bondage pictures. The victim agreed to having one cuff placed on his wrist. They were watching the Exorcist video, and Mr. Dahmer passed out. There was no sexual contact as of this time. The victim's shirt was off, and he did not know why he passed out, and I have in quotes here that he appeared rather upset and disappointed in himself for letting this happen. Quote, that's what triggered the whole thing, meaning his arrest, unquote.
Sorry, the portion that's in quotes is that's what triggered the whole thing, the arrest. Is that correct?
That's what Dahmer said, right?
Yeah.
I might add that, there were a few times during my interviews that he showed the most emotion. And this is one of the times that Mr. Dahmer definitely perked up and was more emotional about, kind of really.
Not hear the last thing you said.
One of the perked up was much more emotional about his arrest, as he was kind of disgusted with himself that he let this happen. There were a couple other times during my interviews that he showed emotion too, but I have not mentioned those. The other individual left, meaning Edwards, and Mr. Dahmer said he woke up in his living room. The police knocked on his door 5 minutes later and asked for the cuff key. The police saw the pictures in the drawer and saw Lacey's head in the refrigerator. Said he did not remember leaving the apartment or the ride to the police station. Said he had about 10 beers that day and was quite mystified as to why he blacked out. He woke up and talked to the detectives. He said he did not feel drunk when he was talking to the police, and he estimated he gave about 15 statements. When asked about his sexual desires since his arrest, he implied that they are suppressed and not on his mind, quote, because of the circumstances, unquote. When asked if he could kill someone again, he said he would not because he would, quote, consider the circumstances, unquote.
Consider the consequences.
Consequences.
That roughly close your interview of that date?
Yeah, that was the end of my fourth interview.
Did there come a time on the 9th of January, 1992, that you met with Mr. Dahmer to conduct a final interview?
This juncture, I'm asking for a sidebar.
And let's hear the exact words being said as the basis for the doctor's opinion, and I think that's not contemplated by the statute. And therefore, I think the doctor, if he's going to testify, should tell us basically what he asked him and what he feels in his answer as reported to him using those notes served to give him and us a reasonable, and the jury, a reasonable explanation of his diagnosis.
If it please the court, it is a taped interview. It's my understanding, Dr. Fosdal can correct me, the taped interview was taken, as it indicates on its face, on the 9th of January, 1992. The report is, the typing apparently was done on January 10th, but on its face, it's done on the 9th, the interview. It does appear to be there's no intent to specifically adduce it as a taped interview. I know we may later confront this issue. We haven't yet decided what format will present the information that Dr. Dietz secured. We haven't reached that as a final decision. But in terms of the interpretation of the law being given by Mr. Boyle, I've never read such a case. It's an interesting interpretation, but it certainly can be no more than that. I assume that with respect to Dr. Dietz's proposal, that I assume has probably excited some research by Mr. Boyle's firm on the issue, and yet none is presented to the court. And my suspicion is that there is no specific case that answers the issue. And it seems to me, this witness is prepared, I believe, we have not conferred on this point, but to paraphrase the question and answer so that it doesn't come across as a verbatim quote. And I could ask him to do that, and I suspect he could do it. So the issue need not be raised right now. We're not attempting to convey to the jury that this is a verbatim. I can ask Dr. Fosdal to modify it a bit so it doesn't appear that way if the court wishes to take it under consideration, the issue. It's not, in other words, I'm not here saying, no, we want to present it as a taped interview. That's not our intent. We're just after the information, not that it necessarily be verbatim. Anytime he paraphrases, though, I suppose at some point Mr. Boyle won't like the paraphrasing. I don't think I would either. I'm not suggesting that it will be quarrelsome about it, but we're not attempting to convey. It's not our design to say, look, we taped this. It's not the intent. We're prepared now to paraphrase. But I would want to say that this is not yielding on the issue. I think to protect the record, it should be made clear that this is precisely what we were talking about at the sidebar, and the court decided to go on the record with it. So the thing need not be decided at this point. I think Dr. Fosdal, he is on the stand. May I ask him if he would have had great difficulty paraphrasing it?
I think he's going to be required to by the court because I'm proceeding under 90403. And I don't think that when we ask a witness to come to the witness stand, we ask him to completely reproduce his examination. And that's what you're doing. If you simply produce a tape recording or a transcription of a tape recording, what we're asking him to do is summarize what his examination is. That's what I expect him to do. It may be that in the course of the examination of a witness, it may be appropriate to go into what in effect are the details of his notes, and we do that all the time. If that becomes necessary, we will do so, but not initially as far as the examination of the witness is concerned. Right.
Did I just confer for 1 minute with the witness? So
Why don't we all take 5 minutes to catch our breath and we'll get back at it, okay? Court's in recess. But
Dr. Fosdal, did you meet again with the defendant on January 9th of 1992?
Yes, I did.
And was that here or in some other facility?
That was here.
And was it in a room near where we are
Same room.
presently? And you met alone with the defendant at that time?
Yes, I did.
And you have some notes from that, is that correct? Some notes you prepared
yes,
from
I
that? And I'd ask you to turn to page 2 of those notes. Was there some discussion between you and the defendant about the subject of necrophilia at that time?
Yes, there was.
And was there any discussion about, in particular, what his and your understanding was as to whether he preferred behavior with deceased, sex with deceased persons or live persons?
Yes, there was.
And can you briefly summarize to the jury what his indicated preference was? Just so the jury understands, these are in a different form, these notes, is that correct?
Yes, they are.
And you need to study it particularly to get that answer, is that correct?
Is your page number 51, or are we on the talking the same?
I'm on page 51, yes.
And your question is, what did he say about being on?
All right, in terms, was there discussion between you and him about whether the body is alive or dead and what comparative pleasures he would draw from that?
I'm not sure where you're referring to on that page.
Okay, let me start at near the top, okay? You ask him about his understanding of necrophile and whether it implied that a person would have to be dead before you could enjoy that person. And did you want to discuss with him what his conception was of being a necrophile?
Okay. The point I was getting at, and one reason I wanted to clarify some issues with him was whether or not the quality of being dead was part of the sexual arousal, or which is more necrophile in nature, or that like he described earlier, that it wasn't the quality of being dead that was what he was pursuing, but more that while a person is dead, he then has full cooperation and the individual is incapacitated and is fully passive, and that it was simply a way of prolonging the relationship, and not that it was the quality of deadness that he was seeking, and that's what gave him the thrill or the stimulation was a deceased body. And
In other words,
and he implied that he agreed with my formulation, that I understood him correctly, that at least so far in the discussion, that my formulation was somewhat true, that it was, again, a means to an end. It wasn't, he didn't need them dead for stimulation purposes.
In other words, did he indicate that he undertook the death to continue the sexual pleasure that he was experiencing with the person while they were alive and unconscious?
Yeah, pretty much what I've been talking about all afternoon.
Right. So that it wasn't necessary that he preferred their body dead, but it was just a way to continue the pleasure, otherwise they'd get up and leave.
That formulation, yes.
Did you, and I'm looking now to the middle of page 52.
I'm sorry, when you say 52, is that night two? So I think that
And was there a discussion at that point about whether it was more exciting to be with a live person or a dead person? I'm looking at about 2/3 of the way down. Whether it was more exciting to be with a live person or a dead person.
The discussion there related to, like you said, whether or not it was more exciting or stimulating being with a dead person than a live person, and he implied that the zombie-like state or a live but impaired or individual who was totally compliant, that would have been better.
It would have been better to have such a totally compliant live person.
Right.
But he'd indicated to you that he had never run into such a person. Is that correct?
True.
And under those circumstances, then, not having such a person available, not having run into such a person, he would proceed to the death and have pleasure with the dead body then. Would that be accurate?
True.
When you asked him particularly if it would be more exciting with a live person, and did he indicate yes?
Yes.
But that they'd have to be in a completely compliant status. Is that correct?
That's what he would like, yes.
Towards the bottom of that page, did you have a discussion with him, reverting back now to the first incident, his discussion about the jogger, right at the very bottom of that page?
Yes.
And you briefly discussed that with him again. Is that correct, the jogger incident?
I think that was the first time I heard about it. He had not told me that before. He thought he had, and then I asked him about that.
Where are we at, Doctor?
Bottom of page 52, Mr. Ball.
That'd be the third page. Bottom of the third page.
And you said that's the first time you talked to you about the
From what I recall, I had not heard about the jogger before.
Did he indicate whether it was his plan to knock him out unconscious or to kill him in that discussion you had with him? I'm looking particularly at the bottom several lines.
The plan there was to knock him out, and while the individual's knocked out, he would be able to
He did not indicate
enjoy homosexual behavior with him in the woods.
He did not indicate to you that it was his intent to kill that jogger or his plan to kill that jogger.
That's true.
Looking on page 54, be the fourth page, you have a discussion with him about any efforts he may have made to locate someone who would establish a long-term relationship with him.
Yes, I did.
And what, if anything, was his response in connection with that discussion?
He implied that he didn't try as hard as perhaps he could have. Living with grandmother certainly would not facilitate having a boyfriend.
And towards about 2/3 of the way down, you inquired as to whether there was any sexual pleasure in the strangling and dismembering that was involved.
That's true.
And when you asked him about that, the assault aspect, the strangling and dismembering, you asked him whether or not that was sexual, and what did he indicate to you?
As he testified or related to me previously, this was not a sexual act for him.
Did you then discuss the work involved in the disposal effort?
Yes, I did.
And what was his comment on that, whether he enjoyed that or
I
not?
just said there was a lot of work involved, and he, quoting him, he said, too much, unquote.
Then into the next page, 55, about mid-page, did you ever ask him whether he had good sex, particularly with the drugged persons?
Yes, I did. I asked him in what manner did he have the most enjoyable sexual experiences.
And what did he advise you?
And he implied that he enjoyed the individuals while they were drugged the most, and he implied that that was he said, quote, it worked rather well.
Right. The problem was, though, that they'd wake up and begin to leave. Is that correct? And then you discussed with him the shortcomings and the techniques he was using, killing these people. Is that correct?
True.
And what was his response basically to that? That it would
Well,
indicate it was better
we
than
were
nothing?
talking about the shortcomings of the deceased technique, and he said the one drawback was that they didn't last forever. And then I raised the question of it's also being illegal, and he said that was the quote ultimate drawback, unquote.
Then and he had a very candid discussion about whether a mouth job is a mouth job on a live person or a dead person. Is that correct?
With all due respect, I don't believe Mr. Dahmer's coming in with those words. So just so it's clear that they're the doctor's words to Mr. Dahmer.
Was there a discussion about various sexual practices, comparing them to a dead and a live body and a dead body?
I was wondering if there was something, sexual contact with a deceased person, if there was something he could do with a deceased person that he could not do with a live person that was so pleasurable, or was the motivating factor here. What can you do with a person in that state that you can't do with a person in a living state that might want you then to be more, let's say, purely necrophilic? Is there something that is particularly arousing or pleasurable about the deceased state that you want to then get to that state, and then you can do this thing? And he implied there was nothing, no particular physical act.
On the top of page 56, did you make that flat comparison whether there was any advantage to having the deceased, and inquired whether otherwise the sexual behavior was the same between a live person and dead person?
It pretty much was. All the advantage he got from was the control of the situation. True.
Did you ask him otherwise, was the sexual behavior the same?
Pardon me?
Did you ask him otherwise, was the sexual behavior the same at the top of page 56?
Yes, I believe I did.
And what was his response?
He said that was right.
And the difference, you pointed out the difference was that by killing them, he would be able to squeeze out a few more hours, a couple of days. And what did he respond to that?
He agreed with that.
And he indicated, did you have any discussion on whether he had ever taken the time to really nurture a long-term relationship?
Yes, I did.
And what did he indicate to you?
Oh, that he had not.
And did you have a discussion with them about his personality type, the type of personality style that he used at the bottom of 56 and then over to 57?
Yes.
And what was the discussion about his style?
He pretty much confirmed what I would consider loner personality traits, or what I call schizoid personality traits, tendencies toward friendlessness, trouble forming relations.
And in the middle of that page, was there a discussion about selfishness involved in doing what he was doing?
Yes, there
in the middle
was.
of that page?
Yes, there was.
And what did he indicate at that time about whether he thought it was selfish or not?
Well, again, I was trying to maybe correlate that. Were he better able at forming relationships with people in general and other gay men in specific, that maybe this might not have happened. And he said that if he didn't have such a desire for quote, total control and domination, then he said, quote, if I wasn't so selfish, and then he, unquote, then he said that what he was doing was, quote, the ultimate in selfishness, unquote.
You had a discussion with him then also at the bottom of page 58 about whether he ever owned a car in Milwaukee. Bottom of page
Yes,
58?
Yes, I did.
And then you had a discussion with him relating to the fact that he always selected victims that did not have cars. Is that correct?
True.
And would you tell us, you then had a discussion about, did he tell you why that was done?
And basically that if he knew the individual had a car at the tavern, he would not consider taking them back because the individual would want to drive his car back and then it'd be on the street, and then he would have a problem with disposing of a car, or certainly the car could be traced, whether it be left at the tavern, which I suggested, or even if the car was back on the street.
So he discussed that in connection with, he always selected a victim that did not have a car. Is that correct?
Yes, that was a consideration, just like their appearance.
Did you ask him in middle of page 59 how much money he was making a year?
Yes, I did.
And what did he tell you?
He estimated $20,000 to $25,000.
Then you had discussion with him about the last incident involving Tracy Edwards. Is that correct?
What page?
I'm at the bottom of page 59 and the top of page 60.
Yes, I did.
You've already related some of that, and you went into further discussion with him about that. Is that true?
In the previous interview, we were cut off, and I didn't really get a good discussion from him as to how how it all came to an end, which is
Right.
most relevant.
You had discussion with him on that day about the altar, too, a temple altar. Is that correct?
Yes, I did.
And can you tell us basically what the subject of that discussion was and what the response was? He describe it to you, what he had in mind?
What page are you on?
I'm on 61.
He had mentioned the altar briefly in an earlier interview, and I never followed up on it. And he did describe to me what that was all about. And basically, he described the layout.
And he had some discussion then that he had read something in the Satanic Bible.
He did mention then that, yes, he was getting into, or had been looking into some satanic beliefs and had bought the Bible. And he concluded, well, again, he didn't express any beliefs that, again, that he was possessed by demons or devils, or that this was psychotically motivated behavior. It just sounded like he was looking into call it some occult kind of thinking.
How long did that interview last, that last interview?
2 hours.
Now, I want you, what did that bring your total to, the total number of hours that you had been in discussion with him?
According to my stop-start entries, it's 17 hours and 15 minutes.
And that had been over 5 days, is that correct?
True.
And it had reached back from October 16 of 1991 until January 9th of 1992, is that correct?
That's true.
So there were intervals and breaks over roughly a better part of a 3-month period, a good part of 3 months that the visits were spread over. Would that be accurate?
Yes.
Now, I'm going to ask a series of questions, and I want you to respond applying those questions to all 5 interviews, all right? During those interviews, did he at any time indicate a delusion to you, what you perceived as a delusion?
No, he did not.
Did he at any time indicate, was there any indication of hallucinations?
No, he denied this.
Sometimes, would you explain to the jury what a command hallucination is?
First of all, a hallucination is a symptom of psychosis, and I'd be happy to elaborate on psychosis. Is a term that refers to a degree of impairment in a psychiatric disorder. Psychosis in and by itself is not a disorder. Psychosis is a degree of impairment. So certain conditions the individual can become psychotic. And what psychosis means is that the individual loses touch with reality or has an impairment in reality testing. Some conditions do not become psychotic. So schizophrenia is a type of mental disease or illness whereby the person can become psychotic. People can become psychotic while severely depressed. In a manic depressive high, being high on drugs, an LSD experience is a psychotic experience. An alcoholic having delirium tremens, DTs, is a psychotic experience. The person seeing bugs and things that aren't there. So there are some conditions can have a psychotic symptoms.
In this particular,
The most common psychotic symptoms are delusions, which are false beliefs, whereby the schizophrenic individual might misinterpret reality and think people are plotting against him and the CIA is tapping his phone and on and on. The person can also hear voices and no one is there, and sometimes these voices tell the afflicted individual to do things, and this is called a command hallucination.
right? In terms of any command hallucinations, in your discussions over those 5 periods, over the 3 months, did you find any evidence of command hallucinations in the defendant?
No, I did not.
In your communications with him, you put questions to him and he put answers to you. Did you find him incoherent at any time?
No, he is not incoherent.
Was there any marked loosening of association?
No, there was not.
Did he at any time become catatonic, either by excitement or go into a catatonic stupor? And would you define that to the jury?
Well, again, these are schizophrenic symptoms you're alluding to or discussing, and he does not have, in my opinion, a schizophrenic illness. Catatonia is another type of schizophrenic symptom, at least most commonly found in schizophrenia, where the person can hold a stiff muscular posture for an endless period of time. Rarely seen these days, more commonly seen in the old days before the introduction of antipsychotic schizophrenic medications in a ward of for example, a state hospital years ago, there might be an individual sitting in a chair with his arm in the air, and that's catatonia.
In your entire conversations with the defendant over these 5 times over the 3 months, did he give any evidence to you at all of being in a psychotic state?
No, Mr. Dahmer is not, his reality testing is good. There's no evidence of psychosis. He does not have a type of disorder that has the potential for becoming psychotic unless, again, referring to that, alcoholism is a type of psychiatric disorder, and some of your chronics or your alcoholics do have withdrawal symptoms accompanied by delirium tremens, which is a psychotic symptom. Otherwise, he does not have, his personality makeup is not a type of personality makeup that is prone to become psychotic. His sexual disorder is not a psychotic type of disorder.
And in your meetings with him, you saw no evidence of any psychosis?
No, he is not a psychotic individual. The diagnostic categories he has are the type that do not have psychotic symptoms, unless, again, referring to alcoholics' psychotic symptoms.
As a result of the examination of the materials that you received, as a result of your examinations of Mr. Dahmer and bearing in mind your training, your education, your experience as a forensic examiner, did you then prepare a report reflecting your conclusions with respect to the issue of mental responsibility in this case for Mr. Dahmer?
Yes, I did.
And you prepared that. That is a several-page report, is it not?
3 pages.
And it is the result of your forensic examination and everything you learned about this case. Is that true?
True.
Do you have that with you?
I do.
Would you read your conclusions to the jury?
Sorry, read the report or read the conclusions?
Would you read the report?
It's dated January 10th, 1992, addressed to E. Michael McCann, District Attorney, Milwaukee County Safety Building, Milwaukee, Wisconsin, in regard to the Jeffrey L. Dahmer examination. Dear Mr. McCann, at your request, I examined Jeffrey L. Dahmer. I examined him at the Milwaukee County Safety Building on October 16th, 1991, October 23rd, 1991, November 13th, 1991, and January 9th, 1992. And also on December 20th, 1991, at the Columbia Correctional Institution. I understand he's being charged with 15 counts of first-degree intentional homicide, and that the alleged offenses occurred between January of 1988 and July of 1991. This examination was conducted in regard to his mental responsibility during the time in question, should have been times in question, and as directed pursuant to Section 971.16 of the statutes. My examination consisted of a study of the collateral materials, a review of his past personal history, a discussion of the charges against him, and an observation as to his present mental status functioning. Available to me was a copy of the criminal complaint, police reports and statements, prior mental health records, and other miscellaneous records. The non-confidential nature of our interview, the reasons for this examination, the present legal proceedings, the nature of his special plea, and the possible future dispositions were discussed with him. He understood this discussion. Mr. Dahmer presented as alert and cooperative 31-year-old single Caucasian male, period. I guess leave out the punctuation. He talked freely, related appropriately, and was an articulate historian. The information he volunteered seemed to be generally reliable and was presented in a forthright manner. A typed copy of my interview notes has been forwarded to you earlier and will not be included in this conclusory report. Throughout my interview, his mental status examination was within normal limits. There was no disturbance of speech or motor behavior noted. His mood did not reflect any undue anxiety, depression, or inappropriateness, other than some blandness or flatness of affect, which, may I explain, or not necessary? It's just he's rather stoic. His thought processes were coherent, and he denied past and present psychotic symptoms such as delusions or hallucinations. He comprehended my questions, and his recent and past memory was quite good. He appeared to be of at least average intelligence. Diagnostically, there's a history of various personality traits, including a tendency towards social withdrawal and trouble forming relationships. Superimposed on his basic personality makeup is a history of long-standing involvement with alcohol, parentheses, alcohol abuse / dependence, close parentheses, and a gay / homosexual sexual orientation. I was not able to substantiate an ongoing type of mental disease such as schizophrenia, a bipolar or manic depressive disorder, or other type of mood disorder, an organic mental disorder, or other type of psychotic disorder. The main area of psychiatric disturbance is obviously in his sexual behavior and adjustment, and is manifested by his capacity to commit several homicides for sexual purposes, and by his capacity to engage in necrophilic behavior. Since his pattern of sexual behavior is clinically rare, parentheses, and perhaps even unheard of, close parentheses, and most unusual and bizarre, no particular single diagnostic category adequately covers this most unusual case. The diagnosis of paraphilia, not otherwise specified, would be a diagnostic category to note the primary area of psychiatric disturbance. In Milwaukee, his sexual adjustment and functioning obviously became more inappropriate and pathological, and he began using a drug-alcohol mixture to incapacitate his male sexual partners. Parentheses, prior to this, he had considered and attempted to use a sawed-off baseball bat and a barbell, close parentheses. His desire to incapacitate his sexual partners / victims appeared to be an attempt to prolong their sexual availability and a means by which he could satisfy his needs for control and to have a, quote, fully cooperative, unquote, parentheses, non-resisting, close parentheses, and, quote, completely passive, unquote, parentheses, non-rejecting, close parentheses, sexual partner. He later started killing / strangling his partners as a means to incapacitate them and to prolong their sexual availability for a few more days. He later tried, but unsuccessfully, to incapacitate them by the use of a rubber hammer and a, quote, drill, unquote, technique. While his partners were incapacitated and or deceased, he would engage in various sexual and other necrophilic acts, as described in my notes. The dismembering and disposal of the body parts did not appear to be primarily sexually motivated behavior, but instead was carried out more as a matter of necessity and after the bodies were no longer of sexual value to him. Certain body parts, and especially the victim's skulls, were kept for quote, mementos, unquote, and were used for sexual stimulation purposes, as were the pictures he took of the victims. The critical question regarding the mental responsibility issue is whether or not a type of mental disease caused him to, quote, lack substantial capacity, unquote, during the time of the actual killing, parentheses, usually by strangulation, close parentheses, of the victims. Based on my examination and study of the collateral reports, I was not able to substantiate that a type of mental disease caused him to lack substantial capacity to appreciate the wrongfulness of his behavior or to be able to conform his conduct to the requirements of law. Parentheses, mental defects / mental retardation is not an issue in this case, and he clearly was of at least average intelligence, close parentheses. His pathological sexual needs certainly explain his motivation for engaging in these offenses, but they did not appear to cause him to, quote, lack substantial capacity, unquote, for non-responsibility purposes. He admitted that he was fully aware of the illegality, impropriety, and, quote, wrongfulness, unquote, of his behavior, and that he lived in, quote, horror, H-O-R-R-O-R, horror of being discovered. He described various steps and behaviors that he engaged in, and from which the inference can be made that he appreciated the wrongfulness of his conduct. Even though his sexual desires were described as strong and, quote, lustful, unquote, parentheses, his words, close parentheses, he described being rather selective in choosing his partners / victims, and he also mentioned certain conditions and circumstances that would deter him or cause him to refrain from engaging in any homicidal behavior. Other factors were also present which help account for these offenses. His ability to engage in various incapacitating techniques for his own sexual needs certainly reflects an impaired sense of conscience and a disregard for the well-being of others, an impairment which appears to have been present for many years and which helps explain the Hicks homicide. Parentheses, he called this the, quote, ultimate in selfishness, unquote, close parentheses. Some degree of intoxication was usually present and was certainly contributory to understanding his behavior. His purposefully trying to keep the relationships, quote, impersonal and, quote, depersonalized, unquote, helps explain how he could view his victims as, quote, objects, unquote, thus making it easier to kill them. As time progressed and as the killings, quote, got so routine, unquote, parentheses, also the various steps for disposal, close parentheses, he admitted, and I concur, that he eventually became more, quote, desensitized, unquote, to the taboo, T-A-B-O, taboo, and abhorrent nature of his behavior. Thank you for this referral, and if you have any further questions, please feel free to contact me. Sincerely, Frederick A. Fosdal, MD, diplomat, American Board of Forensic Psychiatry, diplomat, American Board of Psychiatry and Neurology.
And that was that, and is that now your conclusion?
That is my conclusion.
And since that time, you've received some additional information. You listened to some of the material submitted to court. Is that correct?
That's true.
Not some, but not all of the testimony. Is that true?
True.
And having heard that additional information, can you state whether or not, to a reasonable degree of professional certainty, medical certainty within the field of, to a reasonable degree of professional certainty within the field of medicine, as to whether or not the defendant at the time of the commission of the offenses listed in the indictment had the substantial capacity to appreciate the wrongfulness of his conduct and had the substantial capacity to conform his conduct to the requirements of the law?
Well, I must impose an objection, a foundation question, because I don't know what part of the testimony he's heard. And I think the way it's phrased is wrong for the purpose of soliciting what he wants. I think he's entitled to ask if his opinion changed based upon anything he heard, but not based upon the things that were before this court, because then I have to ask him what he heard and what he didn't hear, and that's just the problem with the question. So I object.
It's perfectly proper if it please the court. Some of the
Well, let me hear the question then. Okay. Counsel, restate the question. There's some question whether we have it accurately in the record.
Doctor, in addition to the material you received from the various sources, and in addition to the material you acquired directly from Mr. Dahmer, did you secure other information?
Yes, I have.
Did you follow some, but perhaps not all, the proceedings here in this courtroom?
I have heard part of the testimony of the other examiners, the preceding examiners.
And to your best recollection, can you recall who those persons were whose testimony you heard?
Oh, I think I've heard parts of and Dr. Berlin and Dr. Becker,
Dr. Wall?
less of Dr. Wallstrom, and parts of Dr. Friedman and Palermo.
And keeping that in mind, and keeping in mind your training and experience, keeping in mind the information you received basically from our office to which you've already adverted, keeping in mind the interviews and the information you secured from the defendant, do you have an opinion to a reasonable degree of professional certainty within the field of medicine as to whether or not the defendant, at the times listed in the indictment for the commission and the information listed for the commission of the offenses charged, whether or not the defendant at those times had the substantial capacity to appreciate the wrongfulness of his conduct and the substantial capacity to comply his conduct to the requirements of the law?
Yes, I do.
And what is that opinion?
That he had such capacity.
You've already, during your testimony, you've adverted a number of times as you related the interviews, you've adverted directly to and commented on wrongfulness. Is that correct?
Yes, I have.
In addition, you also, there were particular items, we won't go into wrongfulness at length because that has not really been a great deal of an issue, but you indicated that there was one particular page, section 5, page 34 of the police, the confession to police. Do you have that with you?
I can find it.
Section 5, page 34.
I haven't.
And you've indicated what he said to you, the various inferences you've drawn bearing on whether he appreciated the wrongfulness. Did you also have cause to examine that page, and did that raise issues or address that issue of wrongfulness in your assessment?
You did.
And would you read that and you relied on this in part in forming your opinion, is that correct?
True.
Would you read that to the jury?
Is something that came out of the police confession?
That's right.
Well, I object to it. It's already been read to the jury.
It's proper for him to state what is of particular import in his formation of his opinion.
I think it's a fiction group.
Mr. Dahmer stated that he was fully aware that the acts he was committing were wrong, and he feels horrified that he was able to carry out such an offense. He stated that it is obvious that he realized that they were wrong because he went to great time and expense to try to cover up his crimes. He stated that he used quite a bit of caution by setting up alarm systems in his apartment, that being in the outer door, the sliding door leading to his hallway, bathroom, and bedroom, and his bedroom door. He stated that he set up a fake video camera and told other homosexuals that he had brought to his apartment that it automatically turned on if his door opened up. His door opened up without the alarm being turned off. He stated that this was all done in order to keep people from entering into his apartment and discovering the evidence of his criminal act.
And this is consistent with your opinion and is also a part of a basis of it. Is that correct?
True.
Did you also, in terms of the alcohol, the formation of your opinion addressing the alcohol dependence, beside what he had told you, and did you also consider what appears in Section 5, page 143 of the police confession report?
I have page 143.
They're particularly about the fifth line. He says, at this time. Would you read that one line and then drop to the next paragraph?
At this time, he stated that he did not drink every day, only when he committed the offenses.
And then the next paragraph.
He stated that when he killed these individuals, he was always drunk, and the drinking helped him get into the frame of mind and made it easier for him. He indicated that he didn't drink every day, but when he planned to get someone, he would start drinking after he planned, and then he was usually drunk when he killed them. He related that he even drank when he was cutting up the bodies. He again stated that it helped to make it easier when he was doing this. He related that he feels that he is not an alcoholic, and the reason he was drinking was due to the fact that he committed these terrible offenses.
Right. In terms of the conformity issue, during your testimony, you've adverted several times to that issue as well. And I'd like to touch on a few questions on that issue. With respect to the discussion you had with him during the time he was in the United States Army, that there were none of these incidences occurred. Did you consider that at all with respect to the conformity issue? And if so, would you share with the jury what the impact of that was?
I guess back in that era of his life, he was having homosexual interests and desires. It's unclear, and the information is mixed as to whether or not he was having, let's say, frank necrophilic desires and fantasies, or violent fantasies, or exactly what his desires were during that time. My understanding was that for sure he was having homosexual interests and desires, and but he was not practicing homosexual during that phase of his life.
And would the same be true when he returned from the military in March or so of 1981 and went to Florida for 6 months and lived in Miami until about September of 81?
I would have the same response.
And with respect to the period that he returned home and stayed in Ohio before going to the grandmother's home?
Same response.
With respect to the period that he then took up residence in the grandmother's home in late 1981, and he went through a period of religious commitment under the influence of the grandmother. And during those periods, he abstained, apparently substantially restrained himself from such activities. Did you consider that in the formation of your opinion on the conformity issue?
True.
And would you comment briefly on that? What that evidenced?
Just that his sexual interests and desires were there. His sexual orientation was there. Exactly what types of desires and fantasies he was having depends on, there's conflicting information on that as to how purely necrophilic they were versus non-necrophilic in nature, but at least.
But he did not act on them, is that correct?
That's true.
And then from that period, when he began to return or started going to the bookstores until November of 1987, when Mr. Twomey died, during that period, he also abstained from any necrophilic behavior. Is that correct?
True.
And in terms of after the Twomey incident, there was discussion about his ceasing effort or not struggling against these proclivities. Is that true?
True.
And what impact does that have in terms of assessing conformity when a person advises you that they were no longer struggling against it, against a particular tendency?
That he had now decided to follow through with his sexual interests.
And that meant pursuing whatever he wished sexually.
To attempt to, yes.
He indicated to you from time to time that he refrained from pursuing a person if that person was unattractive. And does he have any considerations on conformity with respect to that?
Your Honor, I think we're now getting to the point where it's terribly repetitious. It's been testified to time and time again by this doctor throughout the day, and I'm going to object to it. Time and time again.
Okay, all of that has to do with conserving time. Mr. McCann, how much longer are we going to be on direct exhibiting?
I think 15 minutes max.
Yes. Go ahead.
Yes, he stated on several occasions that the attractiveness and the appearance, physique of the potential partner was extremely important, and that was a screening consideration. It was he demonstrated that he had the capacity to control his desires and interests if, in fact, the suitable, attractive partner was not available.
I asked you, I believe, on direct examination, what you drew in terms of conformity from the incident involving Mr. Flowers at the grandmother's house, from the incident involving the juvenile, which we know as SS, when he had a residence on North 24th and West Wells. And I believe I also asked you the implications for conformity with respect to the fact that he did not slay LP, although he undertook to do it. Is that your recollection? Did I ask you on those issues on conformity? The implications for conformity in those issues?
You did that during my reading of the notes?
Yes.
I remember Mr. Flowers, and I don't remember SP. Did we talk?
All right.
We
The
did talk
SS
about
was the juvenile that that led to the second-degree sexual assault. Perhaps I did not ask you the implications of the fact that he did not, although he gave him the drug, undertook some activity, he permitted the juvenile to leave.
True.
Would you suggest to the jury what the implications were on conformity on that issue?
Well, there were factors that would help him control himself. He had the capacity to pick and choose and be selective as to which people he involved himself with and which individuals he would kill.
I did ask you about LP, I'm sure. With respect to the fact that on some days that he said he was too tired or he was too busy at work to undertake activities of pursuing and targeting a particular individual, would you explain to the jury the implications of that with respect to conformity?
These appear to be factors, variables that if you were feeling that way, that these would assist his refraining from engaging in any homicidal behavior if he was too tired and what have you.
And would you
He
explain?
was able to refrain.
I'm sorry, you finished?
I'm finished.
And would you explain to the jury the implications of the defendant's decision that he would not select persons as victims who did not have cars?
We've been through that objection. It's repetitious.
For the next 10 minutes, I'm going to overrule those objections, Mr. Boyle. Thereafter, I probably will be very upset.
Right in at 10:01, Your Honor.
Basically, that's another external factor, a circumstance that gave him reason to refrain. That he then could, it reflects that he had the capacity to refrain if the circumstances were not of his choosing.
Particularly, you indicated in your direct testimony that he said on occasion that if he did not find anybody attractive, he would just go home. What are the implications of that in terms of the conformity issue?
That the unavailability of a unsatisfactory partner, he did not do anything.
On direct, you indicated that when you asked him what it would have taken to stop him from killing, he said, quote, to agree to make it permanent, a longer commitment, close quote. What are the implications of that answer for the issue of conformity?
Simply that this was another circumstance, that if this option were available to him, that he would then put aside any homicidal inclination, put that inclination under control, and attempt to pursue the relationship alternative.
What, if any, implications for control are there to the fact that he only killed persons who he was able to secure, whose presence, with the exception of Tuomi, he did not kill victims unless he was able to remove them to a secure situation, his apartment or the grandmother's house or his home with respect to the Hicks slaying? What implications, if any, are there for the issue of control with respect to those facts?
But object to this on the basis that control is not the issue, it's conformity. Objection in the form of the question.
I'll withdraw the question. Can you advise the jury as to what the implications are for conformity with the law with respect to the facts that, with the exception of Tuomi, all of the slayings that were discussed were performed by the defendant in a particular dwelling or apartment where he chose to have it occur?
This relates to the issue of preparation, channeling and controlling your desires, your impulses, to a set of circumstances in which will minimize your detection, apprehension, discovery. And if you have such control, and this control can last even over hours, let's say from a ride from Chicago to his apartment, who knows how many hours that would take, that when you have this much control over your desires, that you can prepare and set up and arrange to this extent, discerning one inference from that is that that individual does not lack substantial capacity of his ability to conform his desires to the requirements of law.
So object to that, move to restrict it to conform your conduct, not your desires.
Well, do you wish to restate that, Doctor, to say
Conform, yes, I'll rephrase it to be able to, that the individual, an inference is that the individual had the capacity to conform his conduct to the requirements of law.
The converse of that question would be that there is no evidence that the defendant, none submitted to this court by either party, that the defendant ever set upon anybody, suddenly attempted to sexually assault them any other place. In other words, in a field, or no matter whether he was frustrated that night or not, no such evidence. Is that the converse implication with respect to conformity? Did the fact that there was no evidence of any person being set upon by the defendant anywhere other than in an environment he controlled, did that have any implications with respect to the issue of conformity?
I would say it's pretty much the same response as to the last question.
And that would be the converse of it. Is that correct?
True.
With respect to this final question, can you explain to the jury what, if any, implications it has with respect to conformity of the law that the following evidence is adduced? That the defendant lied to doctors to secure a particular sleeping potion, that he would make preparations in advance, and with respect to planning for a particular evening to bring a person back, a victim, to his apartment, that he would target such individuals at the closing time in bars in many situations, that he would induce that individual generally with offers of cash for selected services to return to his home, that he would return to that home by cab generally and alight from that cab at least several blocks from his dwelling, that after arriving at the dwelling, he would induce the individual to imbibe a drink that contained a particular potion, that he would thereafter kill the individual, strangle him, and in some circumstances undertake sexual activity, that he kept, maintained, and procured at his residence equipment to acidify flesh and to acidify bone, and the equipment to he had the availability of toilet to flush the sludge that resulted therefrom, or to package such sludge and to drop it in a nearby disposal unit. And that in that fashion, he got rid of the remains. That at that dwelling, he maintained a security with respect to alarms, particular dwelling where the slayings took place. He equipped such facility with alarms and additional locks. Can you tell the jury what, if any, implications such activity has with respect to conformity?
Parts of that statement relate to the wrongfulness issue. Parts of that statement reflect that he did appreciate the wrongfulness of his conduct. Parts of that statement reflect in regard to the preparation and the extent of planning and preparation he went to, that again reflects that if he had was able to participate in such degree of preparation and planning, premeditation, that I would infer that he did have the capacity to conform his conduct to the requirements of law if he so chose.
Thank you, Doctor.
Mr. Boyle, I trust that your cross-examination will be a little more than 5 or 10 minutes. Is that a fair statement?
That's correct.
Okay. I think that we'll reconvene Monday morning at 8:30. Court's in recess.
All right, today.